Welcome, Judge Tott.
How are you all?
Good.
Good.
And you can start whenever you're ready.
All right, thank you, Ms. Law. Well, good morning. Again, as Ms. Law's indicated, my name is Patrick Tott. I'm the Chief District Court Judge for the 3rd Judicial District in northwestern Iowa, and it's a privilege to be here in front of you today. I've had the honor and privilege of serving the citizens of northwest Iowa for nearly 30 years in a variety of roles. I started my judicial career in 1994 as an associate juvenile court judge at the age of 27, having been appointed by the district judges in the 3rd District at that time. I've also had the privilege to serve Woodbury County in the associate district court system for 15 years as a magistrate before becoming a district court judge 8 years ago, the last year of which I've served as the chief judge for the 3rd District. As the chief judge, I'm responsible for carrying the same caseload as my other 11 district court judges in the 3rd District. But in addition to that, I'm responsible for the administration of the court system throughout the 3rd District and manage the day-to-day operations from our judges to our clerk staff to our juvenile court officers, etc. So I believe I bring a broad spectrum of experience as a judge to this application process, and I think I could bring that to the court if I'm ultimately selected. In addition to that, though, I've also had the privilege to serve as a private attorney for 23 years, despite having nearly 30 years as a judge. And my experience as an attorney has also been very diverse, as my experience as a judge has been. I had an honor of working at the start of my career in a larger law firm. Mr. Gray will remember, because I went to work for him 30 years ago at the then Eidsmo firm, which is now the Heidman firm, which had over 20 attorneys and still does at this time. But I've also worked in very small firms. I worked with just 1 or 2 partners, and I worked for many years as a solo practitioner. So I also have experience in the issues and challenges that are faced by attorneys in private practice from all spectrums, from, again, larger firms to smaller firms, and I have an appreciation for what they face on a day-to-day basis, as I do for all trial court level judges. I know what it's like to work in associate district court. I know what it's like to work in district court. And I can bring those perspectives to the Supreme Court if I'm given that opportunity. And as we all are aware, the Supreme Court has multiple responsibilities. We adjudicate cases on the Supreme Court, but we also do the administrative side, where we have to set policies and procedures and how our system of justice in Iowa is going to operate. And I think to be effective and to be an effective member of the Supreme Court, you have to have those perspectives to bring to those decision-making processes. You have to know what your decisions, especially on the administrative side, are going to do to the day-to-day operations of the associate court or the district court. And if you don't have that perspective, there can be unintended consequences that you have to face, and I believe I've discussed with many of you what some of those can be during our individual sessions, and so I won't go into detail with those now with the limited amount of time we have. But I think those experience and that depth of background would make me a valuable asset to the Supreme Court if I'm given that opportunity. But having experience is only one aspect of being a good Supreme Court justice. You also have to have the intellectual capacity and ability to serve. You can have all the experience in the world, but if you don't have the capacity to use that experience, it's not worth anything. I think looking at my track record, and again, we have 30 years of experience again to look at here, going back as far as my academic career, I've always had success. I was salutatorian of my high school class of 194 students. I graduated 11th out of 154 with honors from law school. And of more significance, I completed my undergraduate degree and law degree in 6 years instead of the normal 7, which required me to take a course load of approximately 17 hours per semester to get that done. I don't think I would have been able to accomplish that without having the necessary abilities and the dedication and hard work it takes to be able to accomplish those type of things. But beyond that, academics, again, is just one part. If you can't put your academics into practice when you enter your career, that's meaningless as well. But I, again, have 30 years of track record for you to look at as far as how I've been as a judge over all of those years. And I think my record shows I have the ability to recognize issues, to analyze issues, and then apply those issues to the facts and law that apply to an individual case to reach good decisions. Now, having been a judge of 30 years, it's impossible for me to sit here today and tell you how many cases I've decided or how many rulings I've entered but it's very safe to say it's in the thousands, over 30 years. And with that, I'm very proud of my appellate record. You can see in my application, I've been reversed. All judges get reversed and have decisions that are determined to have been wrong. But my reversals you can count on basically one hand of thousands of decisions over 30 years. So I think my track record would show and reflect that I do have the intellectual capacity, the ability to analyze issues and cases, the ability to make tough decisions in cases that are sometimes tough, and then have a good appellate record to support the decisions that I made. Now, there's a big difference between being a Supreme Court justice and being a district court judge, and that as a district court judge, I simply make the decision and enter my ruling. As a Supreme Court justice, if I'm given the opportunity to so serve, I will simply be one of 7 people on the court that have to make the decisions as a group. My decision by myself as a Supreme Court justice doesn't mean anything unless I can convince at least 3 other members of the court to agree with me. And that leads me into what I think is the third prong of making an effective judge or justice, and that's your temperament. You have to be able to work with people, get along with people, negotiate in such a fashion that you don't burn bridges with the people, and be collegial with your other members of your court. If you're not able to do that, your other colleagues aren't going to listen to you. They're going to ignore you. You will not be effective. And it's easy for me to sit here today and say that I believe I have the right temperament. But again, don't listen to my words. Look at my record is what I would plead to you all. The last time I stood for retention, and as judges, district judges, Supreme Court justices, we have to stand for retention every 6 years. The Bar Association always takes a poll of the attorneys that appear in front of you leading up to your year where you're up for retention. And I'm very proud to say the last time I was up for retention, my retention percentage was 100%. There wasn't a single a single attorney that appeared in front of me that voted no to the question, should this judge be retained? 100% said yes. And I think when you look at that from the perspective of not necessarily being 2 or 3 years as a district court judge, but having been a judge for now 30 years, and to have 100%, there's nothing I'm more proud of. In 30 years, you would have to believe somebody would say no to you. But I think that speaks volumes without me having to say it as to what my temperament is and how I approach people, how I treat people, and the respect I give to people that I work with and with my colleagues in the court system. And so I think when you consider the other applicants that are appearing here before you today, I have the unique combination of all 3 of those attributes. 30 years of experience on the bench, 23 years as an attorney, my appellate track record of thousands of decisions with only a handful of reversals, and then my temperament to go along with that. We have 4 other very good quality applicants, and they all bring things to the table. But I don't think they bring the same combination to the table that I do. And so I'd ask that you consider that as you're entering your decision-making process. One other thing I think is important as well is from the perception of the court system. As we were leading up to this vacancy and people were anticipating Justice Apple to retire because we all knew he had to at 72, several people came to me and encouraged me to apply again. I've applied in the past and have not moved on, so people were concerned that maybe I wouldn't want to go through this process again. But people encourage me because they think it's important to have Northwest Iowa represented on the court. As you look at the makeup of the court today, there's a very narrow corridor that runs from Harlan through Des Moines, through Cedar Rapids to Davenport. If you live outside that corridor, there's no representation on this court as it stands today. And again, don't get me wrong, I think all 7 members are extremely good and highly qualified members of the court. But from a public perception, people in Northwest Iowa, people in other parts of the state that are not represented, they lose connection to the court. They lose faith in the system because they don't have any connection to it. It's simply the folks in Des Moines making all their decisions, and there's nothing to tie them to the court system. So I think a consideration also needs to be given to that perception. Allow people to think that Supreme Court justices aren't these people that just simply live in Des Moines in this nice fancy building. They are people who go to church with us, the people we see at the grocery store, the people you see out walking their dogs. We are all the same, and they can relate to the people on the court. And in this day and age when there's always, it seems like every year, a constant struggle between the judicial branch and the legislative branch, whether it be for funding or other things, public policy and public perception, I think, is a very important thing that we need to consider and perhaps make a little broader diversity geographically of the members of the court. I don't think can do anything but help in that process. But again, I know I have a very limited amount of time, and I know that some of you will likely have some questions for me, so I don't want to use up any more of my time. But I'd be happy to answer any questions, Ms. Law, if there are any.
Thank you, Judge Tott. Mr. Hoytink, would you like to begin?
Yes, you've had a varied and long experience holding various judicial offices in Iowa and Nebraska, and on tribal land.
Right.
Have you sat in a role where you served in an appellate capacity, a judge of another decision?
Well, yes, no. Yes, I have, as that any appeals from district associate court or from magistrate court can appear in front of district court judges. So I've seen several small claims appeals that go first to the district court level, or simple misdemeanor appeals that I have to review the record of what transpired either in associate court or district court, or excuse me, magistrate court. And so, of course, the records that we have sometimes in an appeal from a magistrate or an appeal from the associate court are not the same as what the Court of Appeals and Supreme Court have. And many times I have to simply go back and re-listen to the whole trial, as the audio recording to make my record. But yes, on several occasions I've had to rule on an appellate basis those decisions of magistrates and associate judges. I've also, in other capacities, for example, as a extracurricular hearing officer for the city of Sioux City, I'm hearing appeals from students who have been suspended for various reasons, and I did that for several years. It's a little different context and a different perspective, but again, I'm reviewing the actions of school administrators to determine if they were appropriate or not under the circumstances when those students appealed. So I've had some various types of appellate experience, not just on an appellate court, though.
Thank you.
Ms. O'Brien?
Thank you. Thank you for your application, Judge Todd.
Thank you, Ms. Bryan.
You indicated that you feel like sometimes people lose faith in the system, and you tied that comment to the lack of geographic diversity. I guess my question is whether you perceive a questioning or a loss of faith in the system because of perceived politics affecting the court. And if that's true, do you have any suggestions about how to overcome it?
Well, no, I would agree with you. I don't think that just geography is the sole reason why there might be some loss of faith in the system. The courts, both federal and state, the risk is that they become political bodies instead of adjudicative bodies, is what we're supposed to do. The beauty of our federal system and the beauty of our state system is it's three prongs of government. You have the executive branch, which is responsible for enforcing of laws, legislative branch, which is responsible for making of the laws, and then the judicial branch for interpreting and seeing that the laws as implemented are followed. And I think a lot of, and especially with the environment we're in today with recent rulings from the United States Supreme Court, put into play, each side, depending upon who's successful, who's not successful, the other side is arguing that it's all political. And there's a perception for that in a lot of different areas, and the process has become politicized. And so it's very important for judges, both trial court levels or appellate court levels, to understand that their role is not to be a lawmaker. Their role is to be an interpreter of the law and to protect the rights of citizens that are protected in the various federal or Iowa constitutions. And when we get away from that and kind of divert from that, that's when the public loses faith, because the court is supposed to stand for something. It's not supposed to change with the winds of who's in power. And that's where I think the most significant damage is concerned. My geographical argument is more just from, I think Tip O'Neill used to say all politics is local. Well, again, the court's not supposed to be political, but your perception is local. So if there's no one there from Northwest Iowa or Southwest Iowa or some other part of the state, again, outside this narrow corridor, my argument could apply to a lot of areas of the state, not just Northwest Iowa. It's that we're not represented. We don't have a voice. If we have a problem, we don't have someone local we can go to. Sure, can you come down to Des Moines and talk to Justice so-and-so and so-and-so, but I don't know Justice so-and-so and so-and-so. I don't have any relationship with that person. Whereas if a justice is located in Sioux City, and I commit today that I will stay in Sioux City, I don't intend to move to Des Moines. If I'm appointed, I will stay and reside in Sioux City. That will create that connection to the court. so that the people can understand that the members of the court are not these folks in Des Moines that really don't relate to us, but they're our neighbor, they're our friend, our colleague. And I think that's the point I'm trying to make with the geographical argument. But to your question, it's more of the political nature of it. And judges aren't supposed to be politicians. If we wanted to be politicians, we run for the legislature. We're supposed to protect the rights of citizens and ensure that the constitutional safeguards are protected for all. And I take that oath very seriously in every role I've had as a judicial officer.
Mr. Graber?
I also thank you for your time and being a candidate and our time together. One question that I didn't get to ask you was you've been a judge for a long time.
Right.
Tell us one of your proudest moments.
Well, my very proudest moment goes back to my magistrate days, and it goes back to the argument of judicial temperament. And it's one of those situations when you're, as a judge, security is always an issue. So I'm in the grocery store one day, and a lady walks up to me who I didn't recognize, but who had appeared in front of me several months before. And it was just a small claims case. But I had ruled against her. But she came up to me in the grocery store, and your initial reaction and thought is, oh boy, I'm going to get chewed out today. But it was just the opposite. She came to me and she thanked me for being fair and giving her a full opportunity to express her position when she appeared in front of me those months prior. And even though I ruled against her, she thought I had treated her fairly and had given her the opportunity to express herself. And she felt so strongly that she wanted to approach me and thank me for that. That is probably my proudest moment. But also the ability to make very difficult decisions sometimes. And going back, Ms. O'Brien, a little bit to your question, sometimes as judges, we have to make decisions and enter rulings that our gut tells us is wrong. And one of the very first things I had to decide when I became a district court judge 8 years ago was a post-conviction relief matter where a gentleman had been convicted of sexually molesting his 3 little daughters. As a father of little girls myself, it's personal. You can appreciate the circumstance. But this individual's Miranda rights had been violated, and they'd used his confession as part of his trial to convict him. So in my gut, I wanted to deny his post-conviction relief application because I saw his conviction. I saw what happened to these 3 little girls. But yet his trial wasn't proper. He had ineffective assistance of counsel. And so my legal analysis told me he was entitled to the relief he was requesting, which was having his conviction set aside and getting a new trial, which was competing against my gut that was saying, I can't do this to these 3 little girls and make them come and testify again. But when you take an oath as a judge, you take an oath to make difficult decisions. And so there I had to make a difficult decision, and I granted his relief because that's what he was legally entitled to. And I had to realize those little girls were going to go through that pain of having to testify again. Now, he was ultimately convicted again, but that doesn't necessarily make that decision any easier because, again, the repercussions to those kids. So again, I'm proud of my ability to make those difficult decisions and to do what the law requires, even though I personally may not agree with it. And I think that's critically important of a Supreme Court justice. I can't let my decisions be guided by what I may personally believe is right or should be. I have to be guided by what the Constitution requires. And sometimes those difficult decisions have to be made. And again, I think my record shows that I'm able to make those difficult decisions.
Mr. Spies, we have time for one more quick question.
Thank you. Good morning. And having been a judicial magistrate myself, you just prompted some flashbacks. And this is kind of a follow-up to Ms. O'Brien's question. The work of the court has become much more visible over the course of our careers. Are there things that you think that the court could do to improve the public image of the court?
Well, again, I think it's making the court accessible to the public, which goes back to my earlier geographical argument. The fact that the court is going out to rural communities and other communities, colleges, community colleges, to conduct cases and being present in the community for access, I think is important. The fact that these hearings today are being broadcast by YouTube and any member of the public can view that, I think is very critical and a very good thing, as are every, oral argument that takes place. Everything that we can do to make the process more transparent and more open to the public, I think is what we need to strive for. And that's what I would strive for, and I think that would come into play with the administrative side of the court and rulemakings that we have to do. And having that perspective, and again, as I indicated before, I think I can bring to the court.
Thank you.
Thank you, Mr. Speaks.
Thank you, Judge Todd. Our time is almost up. We thank you for your application, and we wish you the best.
Thank you very much, Ms. Law. Thank you all.
Thank you.